Today we're going to talk about whether the police can search your phone without your permission. Let's start.
Imagine this, you're driving home after a long day. Suddenly flashing red and blue lights appear behind you. You pull over, the officer walks up, asks for your license, registration, and insurance. Everything seems normal. Then the officer says, "Can I see your phone?" Maybe you're not worried. Maybe you have nothing illegal on it. Maybe you think refusing will make you look guilty. So what do? Can police actually search your phone? Can they force you to unlock it? Can they scroll through your photos, messages, emails, social media accounts, and search history? Or does the Constitution protect you? The answer is more complicated than most people realize, and making the wrong decision could have serious consequences. Today we're breaking down exactly when police can search your phone in the United States, when they can't, and what rights every American should know. Before smartphones existed, police searching someone's pockets was a relatively small thing. Maybe they'd find a wallet, maybe a few receipts, maybe a piece of paper with a phone number written on it. But modern smartphones are completely different. Think about everything stored on your phone: your text messages, private conversations, photos, videos, banking apps, medical information, search history, location history, social media accounts, emails, work documents, passwords, personal notes. In many ways, your phone contains more information about you than your own home. That's exactly why courts treat phone searches differently from many other searches. Because searching a smartphone isn't like checking someone's pockets. It's more like opening a digital record of someone's entire life. Here's the rule everyone should remember. In most situations, police need a warrant before searching the contents of your phone. A warrant is a document signed by a judge. To get one, police generally must convince a judge that there is probable cause to believe evidence of a crime will be found. Without a warrant, searching the contents of your phone is often unconstitutional. But that's only the beginning of the story, because there are important exceptions. In 2014, the US Supreme Court decided a major case called Riley versus California. This case changed how phone searches work in America. Before this ruling, there was a lot of uncertainty. Police often argued that if they arrested someone, they could search the person's phone just like they could search pockets or belongings. The Supreme Court disagreed. The court recognized that smartphones contain enormous amounts of personal information. The justices essentially said a phone isn't just another object, it's a gateway into a person's private life. Because of that, police generally need a warrant before examining the contents of a phone seized during an arrest. This became one of the most important privacy rulings in modern American history. Many people believe that once they're arrested, police automatically get unlimited access to their phone. That's not true. If police arrest you, they can usually take possession of the phone, they can secure it, they can keep it as evidence if legally justified, but simply being arrested does not automatically allow officers to start reading your texts and scrolling through your photos. In most cases, they still need a warrant to access the phone's contents. That's a huge difference. Taking the phone and searching the phone are not the same thing. Now let's talk about the mistake people make every day. Police may ask, "Do you mind if I take a look?" Or, "Can you unlock your phone for me?" Or, "You don't have anything to hide, right?" At that moment, something very important happens. If you voluntarily agree, you may be giving police legal permission to search. And once consent is given, many legal protections can disappear. That's why lawyers often emphasize a simple principle. If you don't want your phone searched, don't consent to a search. You can be polite, you can remain calm, but consent changes everything. Many people worry that refusing consent makes them look suspicious. Legally, refusing consent is generally exercising a constitutional right. You do not automatically become guilty because you decline a search. You are not required to help police investigate you. Your rights exist whether you're innocent or guilty. That's the entire purpose of constitutional protection. This is where things get complicated. There is no single answer that applies in every situation. Different courts have reached different conclusions depending on the facts. Generally speaking, there is a major distinction between something you know and something you are. For example, a passcode is something you know, a fingerprint is something you are, facial recognition is something you are. Some courts have treated these situations differently because Fifth Amendment issues can become extremely complex. Outcomes may vary by jurisdiction and circumstances. This area of law continues to evolve. Legal experts often describe phone unlocking cases as one of the most rapidly changing areas of privacy law. What if police have a warrant? A warrant changes the situation significantly. If a judge authorizes a search warrant for the phone, police may be able to examine information specified within the warrant. But even then, warrants have limits. A warrant is not supposed to be an unlimited fishing expedition. Courts often expect warrants to be reasonably specific. The exact scope depends on the facts of the case. Can police search your phone during a traffic stop? Normally, a routine traffic stop does not automatically give police authority to search your phone. Getting pulled over for speeding does not mean officers can start looking through your messages. The existence of a traffic stop alone is generally not enough. Other legal factors would typically be required. What about border crossings? This is one of the biggest exceptions Americans should know. When entering or leaving the United States, border authorities often have broader search powers than ordinary police officers. Courts have historically allowed certain searches at borders that would not normally occur elsewhere. Phone searches at borders have been heavily debated in courts. The exact rules can be complicated and continue to develop. Many legal experts agree on one thing: privacy expectations at borders are often different from inside the country. Can police read deleted messages? Many people think deleting something makes it disappear forever. That is not always true. Sometimes information remains recoverable. Sometimes copies exist in cloud backups. Sometimes data exists on company servers. Sometimes forensic tools can recover information. Whether police can legally access that information depends on the circumstances and legal process involved. But deleting something does not guarantee it is gone forever. What about social media? Let's say police cannot access your phone. Can they still see information from your social media accounts? Possibly anything publicly visible may be accessible without searching your phone. Public posts are generally not private. Photos you post publicly can often be viewed without touching your device. This is why privacy settings matter more than many people realize. Common myths. People believe when if I'm innocent, I should always consent. Being innocent and waiving privacy rights are not the same thing. The Constitution does not only protect guilty people, it protects everyone. Myth 2: police can always search phones after arrest. Not necessarily. The Supreme Court's ruling significantly limited automatic phone searches after arrests. Myth 3: deleting data makes it disappear. Not always. Myth 4: police need permission in every circumstance. Also false. There are exceptions, warrants, and special situations that may allow searches. Myth 5: my phone only contains photos and texts is incorrect. Modern phones contain far more information than most people realize. Location history alone can reveal an enormous amount about someone's life. Why this matters: many people carry their entire lives in their pockets. Think about it: where you go, who you talk to, what you buy, what you search, what you believe, what you fear, what you dream about. It is all stored in a device that fits in one hand. The legal battle over phone privacy is really a battle over personal privacy itself. Courts understand that technology has changed the world. The legal system continues trying to balance two competing interests: law enforcement and citizen privacy. Finding the balance is not easy. That is why phone search cases continue reaching courts across America. So can police search your phone without permission? In most situations, no. Generally, police need either your consent, a valid warrant, or a recognized legal exception. But the details matter.
That's all for this video. For more information, watch these videos.